Josh, in response to the application, first of all, by the time Senior Counsel Lukwango made the application to stay the proceedings and also ask for the record, this court had made a ruling to the effect that the application number 01 of 2025 be heard in chambers. As the magistrate or the trial magistrate was standing up, counsel simply said he has an application to make. That in itself was irregular, because at that time the hands for applicants and the respondents were tied because the ruling had been made. The only way senior counsel was by all means supposed to make that application was to seek leave of this court, which he never sought. That in itself hits the applicant's hands down. That said, my senior colleague talked about so many things, including jeopardizing the case for applicants. However, we on record as prosecution for ensuring an expeditious trial, an expeditious investigation in this matter. We wish this court to take a note of the fact that the prosecution is being twisted by the accused persons, in which case the intention is to delay both the investigations and the trial. So, on the other hand, as the prosecution is trying to execute its mandate, it is being blocked, it's being frustrated, it's being twisted by the defense, which shouldn't have been the case. We expected the defense to be the main facilitators of the first investigations and the trial of this matter, but we are surprised. Defense made an application and cited several provisions of the law. He cited section 17A of the Adjudicator Act, 17.1 of the Adjudicator Act, which talks about the supervisory powers of the High Court over Magistrates' Courts.
As long as I'm not captured there.
Most obliged. And also cited there, he cited the section 33 of the Educator Act. Let me read it verbatim, because what the press to hear. They bring this application under section 33, which talks about treatment of life imprisonment or imprisonment for life in any enactment. That is the law under which the application was brought. This is bad law. This is bad law. Your worship, the details are there, and we wish court to capture it as part of the application. 2. counsel made a prayer to stay proceedings, that this court stays the proceedings. However, that assertion, or that prayer, is not grounded. He never provided or cited any authority, either statutory or case law, that gives this court, empowers this court to stay its own proceedings in a scenario where it has been just informed by the applicants that they intend or they anticipate to make an application for revision in the High Court. This court is not supernatural. This is not a court of prophecy that will determine that the applicants are going to make an application for revision in a 2 or 3 or 1 month time. The only court that has the powers to stay the proceedings before this court is the court that is doing the revision. And therefore, the applicants to that effect in this application should first of all have sought that order from the court that will hear the application for revision. Because that court has control over proceedings before it. And therefore, it can tell the timelines that the said application will be heard and disposed of. Which luxury, your worship, this court doesn't have. And therefore, it is redundant. It is a redundant prayer to ask for stay of proceedings in a lower court. This court cannot again stay proceedings before it without evidence that an application for revision has been made. We don't operate in anticipation. Courts of law operate on facts and evidence. So the issue is, what if the applicants file the application for revision after 1 year? So our view, my colleague will submit on the record of proceedings, but I am of the view that this court does not have powers to stay its own proceedings without grounded statutory law and case law. We were supposed to have this matter heard in chambers, and I believe that this court will not have erred in any way to have application number 01 of 2025 heard today and disposed of, so that we fast track the investigations in this matter and ensure a speedy trial for the applicants in the main case, that is 008 of 2025. The public, your worship, my senior colleagues submitted about that, how it is going to be done. The public and the press have less contribution in application number 01 of 2025 because they are not going to make an argument before this court. None of them saw an affidavit on record, and therefore their input is at the periphery. Their role is peripheral, if I'm to say it. My colleague will add on that.
the sections that have been cited by our land friends, that is section 17, which gives supervisory powers to the High Court over the Magistrates Court, and sections 48 and 50 under the Criminal Procedure Code that purposely relate to the nature of proceedings in revision, gives the High Court these powers to call for and examine the record of any criminal proceedings before a magistrate's court for purposes of satisfying itself as to the correctness, the legality, the propriety of any finding, sentence, or order recorded or passed, such as the one this honorable court gave, and as to the regularity of any proceedings of the magistrate's court. These powers are solely given to the High Court, and therefore, for the defense purport to ask this honorable court to inherit itself of these powers is not correct. The leave of court that my colleague earlier commented on or submitted that they should have sought leave from this honorable court, it is their right to apply for a record of proceedings and ruling of this court. However, for it to be the basis upon which they want to file an anticipatory revision should not be entertained by this honorable court. And it is our humble prayer that it is misconceived and they should file these applications before the right court as they have adopted. And we pray that this honorable court be pleased to have this matter heard as directed and in its order. So sound.
Their perspective.
So please just respond.
Yes, I am responding, so that my colleagues respond appropriately. My senior colleague, Mr. Lukwango, premised the application in section 48. That was his section. He referred to section 17 in support of section. What he said was that he had instructions to refer the matter to revision. It is in section 48 and not section 17. Your Worship, under the Judicature Criminal Procedure Application Rules, SI 13-8, that process can be commenced by letter. It is therefore erroneous and perhaps deliberately so, because I don't want to assume that he doesn't know that you don't need to file an application. So when council says you can't file an application in 1 year, I don't want to assume that you are letting go your thought process. It wouldn't surely take council 1 year to write the letter. In any event, the letter has been written, and perhaps for the system would have shown you that the application is there. Your Worship, the instructions of the applicants are to seek a revision, not an appeal. The section cited do not require leave of this court, and we need to be emphatic. We are not here to ask for permission of this court. It is a right to refer the matter to revision. It is nowhere indicated that we must seek permission of this court. So again, because I know that Mr. Bilibun cannot see this, I don't want to assume that circumstances are causing him to do what is wrong, especially when it's still the early part of the month, when all of us have just been paid.
Objection. Let counsel please restrain.